Welcome to the Probate Nation. My name is Richard Ruddy. Probate is a process to transfer the title of probate assets to the beneficiary of a deceased person. To do so, you need to get yourself duly qualified to probate those assets. And that authority works for probate assets located in the state where you are qualified. Unfortunately, that authority does not automatically extend to probate assets located in another state, such as real estate from a prior home not sold, or maybe a beach house that was a second home. But that authority can be acquired through a process called Ancillary Probate Administration in the state where those assets are located. In the show tonight, we will learn the nuts and bolts involved in undertaking an ancillary probate in Maryland, from how to initiate, steps to be taken after qualification, and how to wrap up the ancillary probate. With us tonight is a Maryland attorney who will share his expertise and guidance on this topic. Our guest is he's the managing partner in the Rockville law firm of Joseph Greenwald and Lake. He earned his BA from the University of Chicago and his JD from the University of Colorado School of Law. His practice focuses on estate planning, administration, and taxation issues. And he has more than 25 years experience helping families through the Maryland probate process. Please welcome attorney Paul Rieckhoff. Paul, welcome back.
Thank you, Richard. It's a pleasure to be here with you today.
Well, look, let's begin. The show's about ancillary probate, but let's just talk about that. That actually is called something different in Maryland. It's called a foreign estate proceeding. Tell us what you're trying to accomplish with that.
Sure. Yes, it's a foreign estate proceeding, and that doesn't mean foreign country in this particular situation. It means for an estate that has been opened somewhere else. So for a non-Maryland domiciliary, non-Maryland resident, they have a probate estate in another jurisdiction, but they have assets in Maryland that require the probate process. So that's the purpose of it. If someone is a Virginia domiciliary, for instance, and it turns out that they have a Maryland beach home, they're going to need to open initiate a Maryland foreign estate proceeding in order to be able to deal with that beach home.
So what are the common, so let's just turn to the common assets we typically need to be probated in Maryland by a non-resident decedent estate would be real estate?
Real estate and tangible personal property that is located in Maryland. Typically, the tangible property, tables, chairs, et cetera, that is in the real estate in Maryland. It could be a car that is registered and titled in the state of Maryland. It's usually limited to those two asset classes.
It could include that golf cart you have down at the beach to get you back and forth to the beach, too, right?
That's right.
Okay. So let's turn our attention now to actually how we begin to initiate the ancillary probate process. So let's begin with, so what court oversees Maryland probates that we have to go to?
Sure. So documents will get filed with the Maryland Register of Wills in the particular county where Maryland assets is located, and that could be in more than one county in the state of Maryland. So if a person has a farm in one county and a beach home in another county, they'll be filing things in both counties.
Okay, so let's refresh our memory from our prior show about the Maryland probate process in general. So what type of documents would I need to bring to Maryland Office of the Register of Wills in order to get that process started? What are they going to look for?
Sure, they're going to look first for an exemplified set of documents from the original jurisdiction. So the probate jurisdiction where the decedent died, which will include the will, letters of administration, whatever it is that court does, that jurisdiction utilizes to open a matter there. Those will get triple sealed by that jurisdiction, and then the personal representative will present those documents along with a petition to fix inheritance taxes in the state of Maryland, the designation of a resident agent in Maryland in case the estate gets sued or process has to be delivered to someone, and a newspaper notice that needs to get published indicating that there is a foreign estate proceeding for a non-domiciliary of Maryland related to Maryland assets.
Okay. Now that inheritance tax, that will apply on the same basis. In other words, if it's passing to someone who's in that exempted category, that would still apply even though I'm a non-resident. Is that true?
Yeah, related to that particular property.
Okay, okay. So what will the Register of Will do once these filings have been received?
So they will take the newspaper notice, fill in a couple of things, and then distribute it to the appropriate newspaper, whichever one was designated for publication of that. And then not a lot else. They don't issue additional letters. There's no other filing requirements unless and until some creditor comes forward to file a claim or some other process related to that property is undertaken in the state of Maryland.
Now that publication, I know we discussed this, there's an obligation to return some proof of publication to the Register of Wills, but I believe you told me that a lot of times the papers are all geared up to just send that back automatically. Is that right?
They will typically do that, but you need to be mindful in a foreign estate proceeding to make sure that the certificate of publication gets filed in every jurisdiction in which there is Maryland assets. So again, if there's a farm in one county, it would need to get filed in that county, and a beach property in another county, it would need to get filed in that county as well.
So would you? Would you deliver more than one notice then to the Office of Register of Wills to do that, or would they use the one notice to send out to both counties?
The notice can be the same, but it needs to get published so that it's in a paper of general jurisdiction in both counties, and then certification that occurred in both counties.
Okay, okay. So once the ancillary probate has been initiated, and I guess publication has taken place, what can be done with the real estate if that's the only asset we're dealing with? What can be done with that at that point?
Well, then the personal representative can deal with the real estate, whatever the intention is or whatever the will may say. So if it's to be sold, they can go ahead and list it and sell it. If it's to be distributed to beneficiaries, they can pursue that process. The only thing they have to be mindful of is making sure that they get the inheritance tax assessed by the Register of Wills and paid, and that they are mindful of the claims timeline to make sure that any claims that occur or that are brought forward in the matter get addressed one way or another prior to distributing or getting rid of all the Maryland assets.
Is there a posting that somehow gets posted in the Register of Wills office saying that the inheritance tax has been paid that a title searcher can find?
Yeah, so they will, the Maryland Register of Wills files and documents are all publicly available. So title searches generally include a title search of probate files as well, and it will indicate that this tax was assessed and that it was paid.
And can that tax be paid out of the sale proceeds and solve that problem?
It can.
Okay.
Yes, it can.
Okay, that's good to know. That's good to know. Well, let's talk a little bit, in a normal Maryland probate, the representative who's been qualified has a whole bunch of obligations and duties. What kind of duties does an ancillary administrator have?
Well, their main duties are to their home jurisdiction. So wherever they got their original letters from, their astral letters from, they need to comply with that. Sometimes that may include telling that court about the Maryland assets, what's happened with them. Sometimes it may include bringing the net proceeds of those assets into the probate matter there. That's their primary obligation. In Maryland, once they've filed those initial documents, there's really not a lot else to do other than satisfy the tax requirements and satisfy the claims that may come forward.
Okay, so we don't have to worry about filing an inventory or an accounting or anything like that like we normally would do for a regular probate.
That's correct.
Okay, well, that's good to know. Yeah. All right, so let's talk about wrapping up an ancillary probate. I mean, so a lot of times with the regular estate, there's a whole process to do that. We got to distribute assets. We got to make sure all these kind of tax returns are filed and so on and so forth. For a Maryland ancillary probate, what do we have to do?
Well, the good news is nothing.
No, that's good news.
Yeah, so And that is, generally speaking, good news. However, for the unsuspecting, it can be troublesome sometimes if they haven't actually done everything they were supposed to do. That can create some issues. But the process is very simple in that regard, and it is designed to be governed by and run upon the letters of administration issued in the other jurisdictions. So there's no closing accounting that has to be filed, or even anything indicating that all the aspects and requirements of the foreign estate proceeding, limited as they are, have been accomplished.
Okay. So I think we talked about the whole process to do ancillary administration to take care of that beach house in Ocean City. So I think the next question is how do we, how do we avoid ancillary probate? And so I guess my first question is, what are the costs I really am going to be incurring in an ancillary probate if I don't do anything with that beach house in Ocean City and I have to go through the process of doing ancillary probate? What kind of cost am I looking at?
Well, the good news is the costs are not high in Maryland for the foreign estate proceeding. They range between $0 and $100. The $100 is the maximum probate fee, filing fee for that matter. You'll also have the publication cost for that proceeding, which just depends upon whatever the newspaper in the appropriate jurisdiction, or newspapers, if there's more than one jurisdiction, may require in that regard, but that's relatively nominal. The only other costs that exist related to these Maryland matters would be if the Maryland inheritance tax applies. So that can come into play, and that, whether you go through the foreign estate process or not, the inheritance tax is something that needs to be dealt with.
Okay, and that's one of those filings that you would use to report when you initially get qualified.
That's exactly right. And if you'd like me to describe that tax a little bit, what it is in the state of Maryland, they tax the right to receive property for a person who is not closely related to the deceased person.
Okay.
So, for instance, if the beach house in Maryland, in Ocean City, was to go to the decedent's niece or nephew, that niece or nephew would have to pay a 10% inheritance tax on the value, the date of death value of that property, as a cost of receiving it. So that would get collected. However, if that property was to go to a spouse or a child, including stepchild, grandchild, step-grandchild, parent, step-parent, brother or sister, grandparent even, those closely related relatives would not have to pay that tax.
And so if they had actually just took title to the real estate, then they'd have to come out of pocket to pay that inheritance tax because they have not liquidated the property.
That's correct.
Okay,
Yeah.
So that's something that people should be aware of. So
yes, absolutely. Need to be mindful of the tax and plan for it.
And certainly, you have a beach house down in Ocean City. I mean, those are not inexpensive, so that could be a pretty big ticket item if you actually have to pay an inheritance tax.
It can indeed, and it'll depend upon the decedent's will too, because the will may include a tax clause that says that the estate itself, so the larger estate that's outside of Maryland, has the obligation to pay that tax on behalf of that recipient. If it includes a tax clause like that, then the non-closely related recipient doesn't have to personally pay it.
Okay. Well, let's talk about, we talked about costs and taxes. Those things are kind of things that make people go crazy because they don't like to pay those things if they can avoid it. So how can we plan as a person that's a non-resident? I have a beach house, a nice beach house down in Ocean City. What can I do to take it out of, eliminate these costs and maybe eliminate the inheritance tax?
Right. What most people do, I think, Richard, nowadays is they'll set up a revocable trust if they have assets that are going to be subject to probate in more than one jurisdiction, and they'll title that Maryland beach house into the name of that revocable trust. Once that occurs, there's no longer a need for a foreign estate proceeding on that person's death. So that's the most common way to deal with it. Some jurisdictions have beneficiary deeds. Maryland has not yet enacted a beneficiary deed statute. There's been several efforts to get that to occur, but thus far we don't have such a statute in the state. There is, and some people will pursue using a life estate with what's called with power, so the power to sell or alienate the property. And in essence, what that involves is a life estate deed where the owner of the property deeds the property to the beneficiary that they want to receive it at their death, but they reserve to themselves a life estate to be able to utilize the property as long as they're alive, et cetera. And they typically will reserve to themselves the ability to rescind that life estate or sell the property at their own direction. So that can sometimes be used, but the most common way that most people want to pursue in this regard is the revocable trust process.
So the revocable trust certainly eliminates the ancillary foreign proceedings action. But what about the inheritance tax? Is that eliminated by putting it in a revocable trust?
No, it's not. And the trustee of that trust needs to be wary of that and aware of it. It's one of the reasons that it's a good idea for that trustee, when they have to open a proceeding like this, to contact a Maryland lawyer to get some help to do that. Because not every state, in fact, very few states have an inheritance tax.
That's true. That's true. So we've been talking about people that own Ocean City Beach House and they live elsewhere outside of Maryland, but sometimes people nowadays are selling their houses in other jurisdictions and moving to the beach because everything's being handled, electronically with Zoom and all different types of electronic methods of staying in touch to run their business. So they have all these estate documents that they've done in these other jurisdictions, and now they come to Maryland. So, are all these documents they bring with them really going to be good in Maryland, or should they do something about that when they first come?
That's a good question. And under our constitutional system, there's full faith and credit for the actions and documents that are valid in one state, they're valid in another. That doesn't, however, mean that those are optimal to be utilized in Maryland once they move here. Our typical recommendation to a person would be to have their documents reviewed by an attorney in Maryland in this particular case, or whatever jurisdiction that they move to so that they can become aware of the differences between the statutes here, the rules here, the taxes here, as opposed to the jurisdiction they came from, and to make amendments as necessary to those particular documents.
So just to kind of drill down a little bit on those documents, though, so if people are using a will to dispose of their assets, we want to make sure the will is executed in a manner that would actually be allowed to be admitted to probate. Otherwise, that throws them into an intestate estate, right?
Correct.
And the other thing I think a lot of times we run into and we see is the medical decision-making document might be full faith and credit, might recognize it, but that doesn't mean a hospital is going to accept it for some reason. Is that a concern that you see happening?
It certainly is for us. I mean, our advice to everyone, really, whether they're coming into Maryland or they're leaving Maryland going somewhere else, is to meet with a lawyer for no other reason than to redo that type of document, just to use the forms that are regularly seen by the doctors and hospitals in the jurisdiction that they're going to be living in. We think that's important. It'd be a terrible event to have a legal opinion received prior to the ability to carry out whatever was in a particular person's living will from another jurisdiction. So that to us is something that's fundamental, that should be looked at and almost certainly redone. The same is true with financial power of attorneys nowadays. In most jurisdictions, they're statutorily based, so they're heavily governed by the statutes of the jurisdiction in which they were executed and which laws govern them. But when you move to another state, not that they won't necessarily work, but those statutes may be different, and there may be protections and provisions of the jurisdiction that was left or of the jurisdiction that you've moved to that won't be fully utilized as a result of the prior document. So having those documents reviewed and updating, most likely redoing them in the new jurisdiction, Maryland in this case, is generally a very good idea.
And the last document, because I know you mentioned early on, many people nowadays use a revocable trust as a tool to kind of manage their assets while they're living and then to dispose of their assets when they die. That's written under the statute of another jurisdiction and a lot of times incorporates powers from that jurisdiction. And we always tell our clients that revocable trust is still good. The problem that we run into is that if you ever want to make changes to that document, the lawyer in the new jurisdiction is going to tell you that I'm not admitted in Nevada or California, so I can't really do this, but they could do an amendment to the document. Is that right? To kind of get that and not affect any of the titling work that's been done. Is that what you see when people come to Maryland?
Yeah, it's pretty common that people will do what's called amending and restating it so that they keep the same name of the trust, doesn't affect any of the titling of the assets that are in it, but they restate the entire document based upon the laws of the jurisdiction that they have now moved to. And at the same time, they can update it for any other reasons that they may want to, such as changing backup fiduciaries, changing the beneficiary, distribution pattern, et cetera.
Sure, and I think that's a pretty common advice, and we would certainly want to tell people that decide to go to that beach house in Ocean City that they might want to talk with a Maryland lawyer about their documents and make sure they're in proper shape. Paul, we're winding down now. Give me some final thoughts about the whole ancillary probate in Maryland, things people should do, and so on. As kind of final words of advice or tips that people should keep in mind.
Sure. Luckily, the Maryland foreign estate process is very simple, as we've discussed today. It's very straightforward. There are some set requirements. The best advice I think I can give to a person is start it early. Get started with it as early as you can in the process in the other jurisdiction. Sometimes that's not always possible to start right away because of contests that are occurring there or other issues related to the estate in that process. But as soon as you have the green light in that jurisdiction, it's a good idea to get started here so that this isn't the last thing that ends up having to be done to be able to finish up the probate of that person's estate at large.
Well, Paul, listen, on behalf of the Probate Nation, I want to thank you for taking the time to come educate us about the work that needs to be done. If somebody needs to do some ancillary probate work, which in Maryland is referred to as a foreign estate proceeding, and of course the importance of updating their documents, their estate documents, if they decide to go ahead and relocate to that Maryland beach house, and then decide to make Maryland their state of residence. So again, thank you for taking the time. It's a great service to the people of Maryland.
Thank you, Richard. It's a pleasure to be with you here today.
You as well. Without a doubt, probate can be complicated and time-consuming, and this is even truer if you need to probate assets in another state through a process called ancillary probate, or in Maryland referred to as the foreign estate proceeding. Many non-residents of Maryland own second homes in Maryland, especially beach houses. Our show tonight introduced you to the process that you'll need to undertake should you need to probate that Maryland beach house owned by a non-resident decedent. While the Maryland process seems consumer-friendly, I would be remiss if I didn't emphasize the importance of consulting with a local Maryland attorney about any ancillary probate you may need to initiate. The guidance of an experienced professional will help you avoid unnecessary work and pitfalls for the uninformed, while shortening the time you need to ride the ancillary probate train in Maryland. This brings us to the conclusion of our show. I hope you found the show helpful, and should you need to undertake a foreign estate proceeding in Maryland. Keep in mind that replays of this show and all shows to date can be viewed on the Probate Nation website. And we also encourage you to go to the Probate Nation website to sign up to receive the monthly newsletter on this and many other probate topics. On behalf of the Probate Nation, I want to thank you for visiting with us.